Assalamualaikum warahmatullahi wabarakatuh and a very good day. So for today's lecture video, I'm going to discuss about government liabilities under chapter 5. So the overview of the whole contents of the chapter is to discuss the government's liabilities in matters of torts and contract, and also what are the government's liabilities when it comes to military personnel. All right, so I'm going to divide the discussion into three. So we're going to look into first the government's liability in contractual matters, and then we're going to look into government's liabilities in torts, and finally, the liability of the government when it comes to dealing with military personnel. Okay, generally, government, as we discussed during our introduction topic, does not really take part in business. It used to be, okay? So they don't get involved in economic part of the country. But nowadays they have evolved and they are very much into dealing with the issues of economy for the public, for their citizens. So they have to make sure that everything is in order. And they are widely involved in various transactions. In fact, if you look into the Ministry of Finance, we now have a Ministry of Finance Incorporated. So even the Ministry of Finance is actually involved in business transactions. So when you are involved in any business transaction, usually there will be contracts and contracts terms and liabilities and responsibilities that you need to fulfill. The same goes if you are a government. So you have to sign a contract and you have to adhere to those contracts that you sign. In fact, this growth in the intervention of government into the economy and business is very much helpful in a way, actually very helpful. For instance, we now have the government introducing statutes that actually help the consumers. I'll give you an example of a hire purchase agreement or hire purchase act that we have. So currently, most people in Malaysia would be buying vehicles using a specific loan we call hire purchase. Okay, dalam bahasa mudanya kita panggil sewa beli, right? So you actually get a loan from any financial institution and you promise to pay within a certain amount of time, for instance, 5 years. So during those process, you are considered as a hirer of those vehicle. And towards the end of the whole contract, you will be given the option to purchase that vehicle. So that is what we call a hire purchase act. And this act, this agreement under this act is very much protecting the consumer. So the government is involved in the matter by setting up this statute, the Hire Purchase Act, so that all the people all the rakyat or the citizen who buy or hire any vehicle using a Hire Purchase Act loan will be protected under the Hire Purchase Act. So the Hire Purchase Act gives a very thorough detail of what are the rights and responsibilities of the owners, usually the financial institutions selling those, giving loans to the people for them to buy vehicles. And it also gives protection to the hirer or the consumers who is involved in the transaction. So this is some of the examples of how the government gets very much involved in determining the issues of economy in a particular country. For instance, the one we had currently in Malaysia. Okay, apart from that, sometimes the government do not have the sufficient funding to make major developments project. I give an example. The usual ones we usually get involved is when we are trying to develop new highways, new freeways. An example like Plus Highway or Pan Borneo Highway. So what happened is we set up agreement with third party or private private companies, so that the private companies, along with the government, will have a joint venture agreement whereby the government will determine how the highway, what sort of highway is allowed and whatnot. And the private entities or the private companies will be the one funding and also providing the expertise in helping the government complete the development of that particular highway. So government in such instance makes such contracts either with these businessmen or companies for the purpose of the country's development and of course for the state economic interest. So these are some of the things that governments are involved with nowadays. So government contracts actually play a very important role nowadays in the running of the country's economic system. So generally, what is a contract? So a contract is an agreement which is enforceable under the law. And these agreements are fixed with certain terms and condition, and both parties must agree to it. And when they have a pen or have, signed the agreement, it became enforceable to both parties. So if one of them breach it, it will become a breach of contract. So there are various forms of contracts out there. So it is actually necessary to distinguish government contracts with private contracts. Usually government contracts are controlled using public law. And in fact, under Article 69, Clause 1 of the Federal Constitution, our Constitution actually allows, through this article, that the country or the federation or the federal government to have the power to acquire, hold, and dispose of property of any kind and to make contracts. So this is a very general allowance from the federal constitution, because usually if we are allowed to buy, sell, get rid of any property of any kind, that means we are allowed to make contracts in a very general sense. Okay, let's have a look at the example given in the box here. So Mr. Riza here has a land in Alupungsu, and the state government of Penang is interested to buy his land at 1 million ringgit. So if he agrees to sell the land, he is said to make a contract with the state government of Penang. But if the state government of Penang fails to pay Riza as promised, he could claim against the state government of Penang, and if he succeeded, the government is said to be liable in contract because they have breached the contract to pay 1 million for the said land. So how do we determine whether the government is liable or not? So we have to refer to two basic statutes. The first one is the Government Proceedings Act 1956. Okay, under section 4 para C of the Government Proceedings Act, or we call GPA, claims are enforceable by proceedings against the government where the claims arises from any contract made by the authority of the government, okay, which has arisen between the subject, and there are civil proceedings involved when we want to bring cases against the government. Section 4C is rather complicated, but we can refer to the example in this box. Okay, for instance, if Lancelot contracts with the federal government to sell his land, the rights are the same as if the contract is made between Lancelot and Galahad, another individual. So if Lancelot does not get paid from the federal government, he can claim using the Government Proceedings Act and Government Contracts Act. One thing you should take note of, remedies such as specific performance. Okay, specific performance ni, maksud dia ialah you force the court to give an order. You ask the court to give an order whereby the court order that the government proceed or continue with the contract. So these remedies is not allowed to be asked against the government sebab you tak boleh paksa kerajaan untuk fulfill contract dia. You can ask for compensation, things like that, but you can't force the government if they decide to back off from the contract. Yeah. So what can the court do? The court can make any other order saying that, okay, it is his rights to get paid for whatever that have been promised and stuff like that. But you can't force the contract to proceed. Okay, another important statute when it comes to government's contractual liabilities is the Government Contracts Act 1949. So under Section 2 of the Government Contracts Act, government contracts must be made in writing, and it must be made in the name of the government, and they must make sure the officer signing the contract possess the written authority from the government, without which the government's contract will not bind the government. So meaning here, if the officer who signed the agreement does not have the authority to actually sign the agreement, then the contract will not bind the government if there is any breach whatsoever. So there are two basic requirements fulfilled here. One, it must be in writing. Okay, tak boleh contract atas angin atau spoken only. And the officer, okay, the key here is the sign must have a written authority to do so. So you can refer to these two cases, Suwiri and Petrojasa, to see what it means by Section 2 punya requirement. Okay, so if you look into these two cases, you can see that in Suwiri, the court decided that the contract is not valid because the officer that signed the contract has no written authorization. However, when we compare with another case, that is the case of Petrojasa, you would notice some difference there. Okay, in Petrojasa, the court has to determine whether there is a valid contract or not because there was no formal agreement made. So they considered that the contracts can be valid. Contracts generally can be validly made in various forms. However, because we have requirement that the Act for it in writing, but is it needed to be formal? So that is one of the issues in question in this case. So the court considered the fact that contracts can be validly formed in certain situations by looking at the implied terms in the agreement made. And they held that in this case, there was a valid agreement because both parties have taken steps to ensure that the agreement took effect. Okay, we have to actually look into the facts of the case. If you have the time, please Google the case and see what is the story behind the decision. And then we have Section 6. Section 6 clearly stated that no contract shall be deemed to be made by the authority of the federal government unless they follow the procedures laid down under the Act. And then under Section 8, no public officers shall be liable to be sued personally. Sued personally ni maksudnya dia saman atas kapasiti nama dia sendiri secara personal. If let's say he signed the agreement, okay, so the public officer signed the agreement under the authority of the government. But if a public officer signed the agreement and he expressly pledges his personal credit, dia yang sanggup menggunakan duit dia sendiri dan sebagainya, masa dia sign kontrak tu dia berjanji atas kapasiti dia sendiri, then he can be considered as personally liable. So you look into the explanation there. So if a government officer contracts on behalf of the government, then we have no issues, no problem. He cannot be made personally liable for the contract. But if he uses his own name and does not mention that, then he is acting on behalf of the government. Then if anything happens, he can be considered or he can be personally liable towards the contracts. Okay, so that is discussion. That is how we look into whether a government can contract. Satu, kedua, the liabilities involved when the governments are involved in any contract or transactions with third parties outside the government.